You're charged with attempted to commit manufacturing or delivery of a controlled substance, penalty group 1, 4,200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison. Here's the thing, you're on probation for burglary of habitation. It's involving the complainant, and there is a no contact order with the complainant. And then you have the case that you've just pled to. And the reason why the police were there is because there was an altercation and there was a female involved and there was a chunk of her hair missing. And you said it was a misunderstanding.
He walked into court thinking he had it made a deal for just 5 years behind bars. But when he walked out, his sentence had nearly doubled. What happened in between was nothing short of a masterclass in judicial power. This is Sergio Martinez, a man facing serious drug charges. His lawyer thought he'd found a clever loophole, a legal plea that would secure a light sentence. The deal was signed, sealed, and ready to go. But there was one small detail buried in the paperwork, a detail both the defense and prosecution missed. And that's the exact thread the judge pulled to unravel their entire plan. In that moment, Martinez had to make a decision that would define the next 8 years of his life. So the question is, was this a judge simply upholding the law, or was she teaching a lesson that Martinez would never forget?
Mr. Martinez, did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Did you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to hold you over for trial?
Yes, ma'am.
Did you understand that your attorney has certain rights? He has the right to have 2 days pass once he's presented with the information and also 10 days to prepare for trial?
Yes, ma'am.
Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case? You're going to need to speak up. The court.
Yes, ma'am.
Court needs to hear. Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review the felony information with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
Yes, Your Honor.
State, are you proceeding on the information as presented?
Yes, Your Honor.
Mr. Martinez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with attempted to commit manufacturing or delivery of a controlled substance, penalty group 1, 4,200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
No, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand if you're not a U.S. citizen, you will be deported, denied re-entry, and denied naturalization?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Are there any applications?
No, Your Honor.
Any objection to the court marking the box that says there are no applications?
No, Your Honor.
All right, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $1,000 fine, no applications. This will run concurrently with 2022 CR 7495. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
No contest. It sounds like a smart legal move, and it is. His not admitting guilt, but his letting the court find him guilty anyway. Everything seems to be going smoothly toward that 5-year deal, until the prosecutor stands up and says something that stops the entire courtroom cold. In an instant, the deal everyone thought was locked in starts to fall apart.
Any evidence?
Yes, Your Honor, State offered State Exhibit 1 and all attachments, and then for the record, State wanted to make it clear that the labs have not been received yet in this case, but at the request of defense, we're proceeding with this case, despite that.
And that's why we're doing the attempted.
Then, all right, we can go off the record. So if y'all are going to do attempted and there are no labs, then there has to be a guilty plea, because otherwise, if the officers just did a presumptive test at a stop or something, that's not admissible into evidence.
He can change his plea, Your Honor, but you want to do that?
Yeah.
He'll change his plea.
All right, so how do you plead?
Guilty.
And just like that, he's trapped. The judge makes it clear, without lab evidence, a no contest plea means nothing. His only way forward is to admit guilt on the record. So he says the word guilty, thinking he's locking in his 5-year deal. But what he doesn't realize is that, in that single moment, he's just handed the judge complete control and the power to throw that deal right out the window.